Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, still the largest taxpayer in the world, Apple avoids massive tax payment to Ireland. As folks may know, Ireland has long been a corporate tax haven. That status was challenged in a 2016 decision against Apple, arguing that the taxes that Apple paid violated EC state aid law. That decision was recently challenged and recently overturned, and we're here to discuss that decision today. Joining me today is my co-host, Matthew Hall, from across the pond for what I think will be a riveting discussion on everyone's favorite topic, taxes, and corporate taxes no less. Hi, Matthew.
Hi, Christina. It's good to be back.
Good to have you. So can you tell me a little bit more about this Apple tax payment and why we should care?
Well, we need to look back a bit to June 2013 when the European Commission started investigating the tax ruling practices of EU member states. These are comfort letters issued by tax authorities to give a company clarity on how its corporate tax will be calculated. And these have become highly controversial cases involving, in particular, the Netherlands, as you mentioned, Ireland, Luxembourg, and Belgium, in relation to the comfort letters concerning a range of companies, including, as you mentioned, Apple in Ireland. These are both general schemes and particular rulings involving individual companies. But the Apple Ireland case, the 2016 finding by the European Commission that you mentioned, is probably the most high-profile one. Ireland was ordered to recover up to around 13 billion euros from Apple. The Commission commented at the time that, quotes, this selective treatment by Ireland in favor of Apple under these comfort letters allowed Apple to pay an effective corporate tax rate of 1% on its European profits in 2003, down to 0.005% in 2014. So wow, this was annulled in
my tax rate.
Yeah, pretty low rates, as you say. Annulled in July 2020, at which point Apple and indeed, strangely, you may think Ireland both welcomed that judgment. Apple pointing out that this isn't about how much we pay, but where we pay it. And we are proud to be the largest taxpayer in the world. Whether that's true or not is, I don't know. But in any event, that's what they mentioned. And I'm delighted to have today Alfonso Lamadrid to talk about this. Well, Alfonso, I'm very excited to be talking about EU state aid today because although not necessarily widely known outside the EU, it's, I believe, a very large, maybe even something like 50% of the European Commission's competition law enforcement work. So could you just take us through what broadly EU state aid law is all about?
Sure. So thanks, Matthew. I think EU state law is an area that is central to EU competition policy, but that for a long time has been largely neglected by competition practitioners, even in Europe. My impression is that this seems to be changing now. I think the prominence that it is acquiring in cases such as this one that we will be discussing today, or in the Brexit negotiations, or in the economic responses to the COVID-19 outbreak, have certainly attracted loads of attention, even from the general public. And the truth is, as you say, state aid currently accounts for most of the DGCOM's decisional output, or also for a very large proportion of its resources. Its economic implications even often dwarf those of antitrust cases. And it also accounts, and this is important, for the very large majority of competition litigation before the EU courts. I think there's lots of stuff going on here that is legally complex and politically sensitive. And I'm aware, Matthew, I still haven't answered your question of what it is. What is state aid law? But I hope I've created some appetite for it.
That's fine. It's good to have that. It's good to have that background and confirming what I say about its importance. So thank you for that.
No, sure. I think especially for the American readers, EU state aid law is a legal regime that seeks to ensure that public authorities in the EU do not distort competition between companies, and more importantly, tax competition between member states. or competition between states more generally. I say more importantly because that is what explains that we have this system in Europe and not elsewhere, including the US. State aid law is unique to the European Union because it is regarded as something indispensable to attain an EU internal market, particularly given the financial asymmetries that you can find across member states in the EU. So there would be no level playing field if member states were just able to throw all of their weight to prop up their own national industries or companies. So the way we manage this competition between member states is by prohibiting measures that we call state aid, and by requiring member states to notify this and obtain the Commission's clearance prior to their implementation. Now, as in the case we will be discussing today, it's not always evident that a measure constitutes a state aid, and over the years, the courts have clarified that we essentially need to meet 4 conditions to qualify a measure as state aid. So first, the measure has to be attributable to the state. That includes any branch of the state and involves state resources. So there has to be money that leaves the pocket of the state or that is foregone by the state. Second, you need to confer an economic advantage to certain companies, and that's an advantage is anything that relieves a company from charges it would have otherwise faced. And I think we will be discussing more about this later on. But this includes anything from direct subsidies or grants to interest and tax reliefs to preferential business terms, so selling land below cost, so you name it. Third, the advantage needs to be selective, so it must favor only certain undertakings or certain goods or services. So that means that if you have a measure that is equally applicable to all activities or companies within a member state, say, for instance, a low general corporate tax rate in Ireland, that does not qualify as state aid. That is a general measure. Selectivity is often the most complex legal question and the key battleground when it comes to fiscal state aid. But this has not been the case in relation to tax rulings. And then the 4th and 5th conditions are almost presumed to be met once you've ticked all the other boxes. So measures must affect trade between member states and threaten to distort competition. When you face any of these measures, the Commission has strong investigative and decision making powers, and it can order member states to recover any incompatible state aid. Of course, not all of these measures are prohibited. It's evident that in some cases you do need state intervention for a well-functioning economy, and there's ample room to declare some of this compatible.
As you say, there are a large number of exemptions from that basic general position. I think it's also worth mentioning, maybe, Alfonso, that an aid isn't an aid or an illegal aid if a market investor would have made that investment into the business or taken that debt, and it's purely done on market terms. Isn't that right?
That's correct, indeed. The idea is to try to approximate the state behavior to that of a rational private investor. And that logic shares some commonalities with some logic that we will be discussing later on about the arm's length principle when it comes to tax rulings.
Absolutely. I think it's very important to re-emphasize that the risk here is on the beneficiary, really. If there is found to be illegal aid which cannot be exempted, as happened here, the Commission or possibly a national court can order recovery plus interest. So you can begin to get very unhappy situation for a beneficiary later down the road. But Alfonso, so we're talking about the tax ruling state aid cases, of which Apple Ireland is the most high profile. How do these cases, you've mentioned this briefly, but how do these cases in a bit more detail fit into this framework with the criteria you mentioned in particular?
Sure. So state aid law often touches upon the core of the boundaries of member state sovereignty, and this is particularly true when it comes to tax measures. So inevitably, and this was also the case in Apple, you will often hear that the Commission uses its state aid powers to introduce some sort of harmonization through the back door. I think it's important to explain that direct taxation is an area that is not harmonized at the EU level, because any legislation in this area is subject to unanimity on the part of member states, and there are several of them, including Ireland, Luxembourg, and the Netherlands, but also others that are more comfortable with the status quo, which allows for tax competition between countries. So different tax rates or rules in different member states are general measures. I said that earlier, they do not qualify as state aid, but they do distort competition, and they also distort the debate somehow about the role of state aid control. And I think that's important background when it comes to tax rulings, even if not really relevant from a legal standpoint. In fact, in the Apple judgment itself, the court dismissed the plea brought by Apple in this regard, alleging that the European Commission did not have a competence to challenge this sort of agreement. I think some commentators have criticized the Commission's crusade against tax rulings as something revolutionary impinging on tax sovereignty. But the truth is that fiscal state aids have always been there. Admittedly, companies in Southern Europe have more experience dealing with this. They were used to being the target. But it is true that until recently, the Commission had scrutinized plenty of fiscal arrangements, not tax rulings. Now, the Commission did open a good number of cases in relation to rulings. I believe so far it has adopted 8 decisions. Some of them have been already decided by the EU courts, like the cases of Apple, Fiat, Starbucks, and the Belgian excess profit system as well. Some of those are still pending before the General Court, including cases involving prominent names like that of Amazon, McDonald's, and Engie. And the Commission continues, even after the Apple judgment, to investigate quite a few others, including Nike's Dutch ruling. I think these are all cases involving different and very complex factual settings. You explained earlier, Matthew, what tax rulings are. They're comfort letters issued by the tax authorities to validate agreements on transfer pricing decisions made by multinationals. So these decisions relate to how to allocate revenues, cost, profits, and therefore taxes within a corporate group in a way that reflects economic reality. There's an internationally accepted standard that this allocation should be in line with arrangements that take place under commercial conditions between independent business. That's what we call the arm's length principle. And EU state aid control kicks here comes in to ensure that member states do not resort to this tool, to tax rulings, to give selected companies a better tax treatment than others. This is, again, to protect competition between companies, but also between member states as regards the attraction of investments. And there are some very interesting legal questions that the cases raise regarding both selectivity and the notion of advantage, the 2 criteria I mentioned early.
And I think we'll get into when we talk about the specifics of Apple Ireland, we'll look at those 2 issues in particular. So I think it's important to note that, as you say, these taxation measures are still really within the competence of member states, but they have to exercise that competence consistently with EU state aid law. Tax rulings are legal unless inappropriate, and that's what the Commission found in the Apple Ireland decision back in 2016. So, Alfonso, what exactly was the issue in Apple Ireland and what was found by the Commission? But firstly, can I ask you, before you describe that to us, many commentators, not least in the US, see this as yet another example of anti-US bias, which is often seen by the European Commission. Is there any validity in that argument?
I don't think there is. If you look at this with a wider perspective, you'll see that the very large majority of the Commission's enforcement in this area has targeted, by nature, it targets EU member states, so decisions adopted by EU member states. But the beneficiaries, the companies really affected by those measures, have almost always been European companies. Now, it is novel that US multinationals are affected by this, but this doesn't mean that the majority of enforcement is directed against them. These cases are the outlier in a way. I think Spanish companies, for instance, to refer to my member state, have been involved in dozens of fiscal state aid cases. I think something that's maybe actually politically convenient is that the 2 companies that have succeeded in annulling tax ruling decisions have been both been American, Starbucks and Apple, whereas the tax ruling decision that was validated by the court was that of Fiat, an Italian company. So I think that also sends a signal about the independence of the EU courts.
Yeah, that's fairly ironic, and it shows that the system works, I would think. Indeed. So maybe we could put that one to bed. Sorry, Christina.
If I may interject on that, what I think is interesting, Alfonso, that you mentioned is that a lot of what's driving the state aid or what's driving the state aid legislation is to level the playing field among member states and to not prop up national champions. What's unique about Apple and Starbucks, whether they be US or other multinational companies, is that it seems to me, at least, that it almost stifles competition to attract foreign investment, independent or sort of separate and apart from member state competition. Has there been any discussion about that, or how at least the impetus or the desire for external competition should play into state aid legislation?
No, certainly the idea at the EU level is to reduce that sort of competition between member states, precisely to attain an EU internal market, because, as I said earlier, there are very significant asymmetries between the budgets of the different member states. And if we allow a member state to spend cash in attracting firms to its own country, we don't allow that from others, then that would create severe problems and fragmentation in the internal market. We've seen that also recently, and this has triggered plenty of discussions in relation to the economic measures adopted to address the COVID-19 outbreak. And the Commission did realize that it was a problem to give carte blanche and to simply open the floodgates for member states to do whatever they could, because some could use a bazooka, but others had to shoot with slingshots, and that was a problem.
So Germany definitely had the bazooka, or has the bazooka during the COVID situation. Another podcast would probably could be done on that one. But Alfonso, going back to Apple Ireland, as mentioned in the introduction by Christina, a well-known tax haven. Apple operates out of Ireland. If you buy things from it, you know that in Europe. But what exactly was the issue there with the tax rulings concerning Apple in Ireland?
Okay, so in 2013, Tim Cook appeared before a U.S. Senate subcommittee to discuss Apple's tax affairs, and he then admitted the group had paid an effective tax rate of less than 2% in Ireland over the previous decade. So the European Commission saw that and rapidly opened an investigation. The investigation concerned two consecutive rulings issued by Ireland in 1991 and 2007. And these endorsed the method to internally allocate profits within two Apple incorporated companies, which were Apple Sales International and Apple Operations Europe. So the Commission's investigation found that the tax rulings issued by Ireland endorsed an artificial internal allocation of profits, which the Commission said had no factual or economic justification, and that therefore it gave Apple an undue economic advantage. And the Commission has often repeated that in 2011, for example, Apple's Irish subsidiary recorded profits of $22 billion, yet under the terms of the ruling, they only paid about 50 million euros in taxes in Ireland. Now, the key aspect of these rulings is that they validated that most sales profit of the subsidiaries were allocated to their head offices. And these were deemed to be non-resident for tax purposes. So all the profits allocated to those head offices were not taxed in Ireland. So in the Commission's view, this was incorrect because the head offices had no operating capacity to handle and manage Apple's business. They had no employees, no own premises, and their activities were limited to a few decisions by directors on distribution of dividends and other administrative arrangements. So according to the Commission, only the Irish branches of these subsidiaries had the real capacity to carry out genuine business activity, and therefore the decision found that the sales profits of Apple Sales International should have been recorded within the Irish branches and taxed in Ireland. And something important here is that the Commission also explains in its decision that the circumstances surrounding the adoption of these rulings made it all seem quite arbitrary. And in the Commission's view, this was sufficient to presume that there was an advantage because the arm's length principle had not been complied with. So basically, the Commission's view was that if the Irish Revenue Service had done its homework, it would have found no evidence that the head offices carried out any activities relating to Apple's intellectual property. But the Commission, however, did never conduct this analysis itself. And then, of course, the decision did not call into question Ireland's general tax system or its corporate tax rate. And because of that, the decision ordered Ireland to recover unpaid taxes between 2003 and 2014 for an amount that was over 13 billion before interest.
So it's important to note, I think, Alfonso, that, as you say, the Commission applied the arm's length principle And also, not only were those profits not taxed of those two subsidiaries not taxed in Ireland, but I believe they weren't subject to tax in any country. Isn't that right?
Well, Apple made the argument that it was that all its profits were taxed in the U.S. I don't know the details of whether those specific profits were taxed somewhere. I believe that those head offices were not tax residents anywhere.
So it's not. I mean, I guess it's not technically relevant to the state aid analysis, but it's an interesting point that if they're not resident anywhere. I mean, I'm not a tax lawyer, as we famously say, but that seems fairly odd to me as an amateur, really. So, Alfonso, that was the decision. 2016 Commission orders Ireland to recover this money, which is estimated at up to 13 billion euros, plus, as you say, interest, which would be in itself quite a large amount, needless to say. That was appealed by Apple. That was appealed. Apple and Ireland both trying to get it overturned. And the General Court in Luxembourg handed down its judgment in July 2020. What did it say?
So I think this judgment has come as a surprise for many, but I would say not so much for those of us who attended the hearing. But first of all, I think the judgment cannot be seen in isolation from two previous judgments from 2019 regarding the individual rulings granted by Luxembourg and the Netherlands to Fiat and Starbucks. In reality, those two judgments already laid down all of the main principles on which the Apple judgment is built. So what the Apple judgment says is really nothing revolutionary. It's nothing that will kill the Commission's policy in this area. It's simply a judgment that fits and develops what was said in two previous judgments from the year before. So I think the main news here is that the Commission lost and that Apple won, and that the case involved a large sum of money and was ideal for headlines. So to be sure, the Commission benefited from those headlines at the time of adopting the decision, and it is taking a hit now that the decision has been quashed. But from a strictly legal standpoint, the Apple case is not necessarily more relevant than the Fiat and Starbucks ones from September 2019. In reality, the Apple judgment confirms most of the Commission's arguments on general principles. So the judgment confirms that it is possible for the Commission to target tax rulings under state aid rules. The Apple judgment, like the two predecessors, recognizes that the Commission is entitled to rely on the arm's length principle and on the OECD's work to determine the existence of an advantage by reference to ordinary taxation. This is something that has been long discussed. And the three judgments send a consistent message that the Commission's policy is not wrong as a matter of principle, but also that the devil lies in the details and that the burden is on the Commission to examine those details. So I think the annulment in this case is due to the Court's view on the proper allocation of the burden of proof. As I mentioned earlier, in the case of Apple, the Commission took the view that the existence of a seemingly arbitrary process created a presumption of a selective advantage. So basically, if it doesn't smell good, it's bad. And this would place, in the Commission's view, the evidentiary burden on Ireland and Apple to show that the advantage did not exist. And something I think that many people have missed is that the Court in the judgment does not hide its dislike of that particular negotiation process and of the ruling itself. So there's plenty of harsh criticism of the ruling in the actual judgment. Even the press release itself states that the General Court regrets the incomplete and inconsistent nature of the ruling. But the Court, however, concludes that these flaws were not sufficient to presume the existence of an advantage, and that the Commission should have done its homework more thoroughly.
So, as you say, the Commission didn't do its homework. The burden of proof is obviously a key issue here. But what did the Court actually say? Why did these apparent misallocations of profits? Why did the Commission get that wrong? Why should it not have been allocated to Ireland, and it should have been allocated elsewhere? What did the Commission get wrong in that analysis?
So the Court doesn't actually take a view of how this should be allocated. It says that the Commission didn't look at it. So I think that the key to understand the whole judgment and this point in particular can be found in an exchange that happened at the oral hearing. So very few people witnessed that. I think this perfectly explains the outcome to this case. So at one point on the second day of hearings, the president of the General Court, who was sitting on that chamber, Mark van der Woude, he asked his first question, and he said that in his view, the whole discussion that had taken place in court for a couple of days boiled down to who needs to prove what. So basically, did Ireland need to prove that the ruling was correct, or did the Commission need to show that it wasn't? So the Commission's position was that the circumstances surrounding the adoption of the ruling, given those circumstances, it would have been a very happy coincidence if the ruling had been approximative to market conditions. And President van der Woude then asked again, but can the Commission fully exclude that there was a happy coincidence? So I think that's a key. Paradoxically, the seemingly arbitrary nature of this ruling led the Commission to simply assume it was wrong. And by contrast, the Commission may have tried harder in cases that did not look as arbitrary, including in Fiat, for example. So I think one can understand the Commission's temptation, but that's precisely the error that the court censors. So specifically, what the judgment says is that the Commission did not undertake a sufficiently concrete assessment of whether those profits generated outside of North and South America should have been attributed to the Irish branches. The court says that the Commission never assessed the functions and the activities taking place in the Irish branches, such as what the design, creation, development of the IP rights or strategic decisions, etc. And the Commission never examined to what extent those activities took place in Ireland as opposed to outside of Ireland, and if so, how much taxable income was appropriate to attribute to those Irish branches.
Yeah, so maybe the Commission should have looked on the back of their products and where it says designed in California or whatever, and thought about that a bit more. Yep. Maybe more is done in California than that.
That was indeed Apple's opening line at the hearing, that the answer to the case could be found in the back of every device.
Very good.
Very fascinating discussion, and I think shows, as is the case in the EU, as in the US, when you're pushing the envelope, you have to bring a very strong case and have strong evidence if you want a court to to make a ruling that's going to potentially have massive impacts down the line. It will be interesting to see what happens in follow-on cases. Before we sign off, we always like to ask a few legal questions of our guests. So Alfonso, again, thanks for joining. We like to ask all our guests to tell us something interesting about themselves that we wouldn't know about you if we just knew you professionally.
Okay, so I think something unusual is perhaps that I grew up in the top of a large hotel that my parents run in Reynosa, a small town in the north of Spain, where, by the way, I am right now on holidays. So during all my childhood and teenage years, I had breakfast at the bar, dined every day in the hotel's restaurant, had a laundry department, and studied at the reception or in dining hall. So I think that was a great formative experience for many reasons. Not for the cooking, of which I'm fond now, but I only took up later as a survival strategy. And
are you still at that? Are you at that hotel today, or does your family still?
Right now, indeed.
Oh, that's wonderful. That's great. And what advice do you have for students or younger lawyers among our listenership looking to do what you do?
So I think they should keep focus on the stuff that really matters. They should sharpen and keep their sense of humor. They should read a lot, especially the actual judgments, which people only tend to read when they lose them, and try to put themselves in other people's shoes. I think empathy is the key skill of any lawyer, getting to understand what drives people and to be able to put yourself in other shoes.
Very true. So moving to the last segment of our podcast that we like to call the Curious Hat.
And now it's time for the Curious Hat.
So Alfonso, in times of when we're together, there's an actual physical hat that we would hand to you, and you could pick out a number from that hat. Obviously, that's not happening today. So I'm going to ask you to pick a number 1 through 25.
So 13.
Okay, 13. So I guess you could answer this for Brussels or for Spain, or Belgium or for Spain. But if you couldn't live in the country where you do now, what country would you like to live in?
I live in Brussels, and I think I would actually live in Spain or Italy. I've come to enjoy Spain increasingly more since I don't live here, and I've come to miss it increasingly more, even if I travel quite often, or at least I was able to travel quite often before the current new normal.
And have you ever lived abroad outside of Europe for any period of time?
Yes, I lived in the US for a year while I was doing my LLM, and I used to spend significant time in the US too. Before that, when I was younger, because I used to play basketball at a decently serious level, so I used to spend some months every year there.
Oh, great! Where in the States?
So Maryland, mostly.
Okay. Wonderful. Well, Alfonso, thank you for joining us today. And to those that you were listening, hope you enjoyed, and we'll see you on our next episode of Our Curious Amalgam.
Thank you so much.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.